International Covenant on Economic, Social, Civil and Political Rights. इसके जो प्रोविजंस है वो इन्फोर्सेबल बताए गए हैं यहाँ पर, इन्फोर्सेबल हैं. तो इट कवर्स द अंडरलाइंग preconditions necessary for health and also the provisions of medical care. The judicially developed modern fundamental right jurisprudence incorporated in the health right as the basic human right, which is presumed to be equally protectable, and this development is in consonance with the international obligations. The right to health should not be understood as a right to be healthy. It should be understood as a right to the enjoyment of variety of facilities and conditions which the state is responsible for providing as being necessary for the attainment and maintenance of good health. The World Health Organization, WHO, articulated the first specific international health and human rights provisions in the preamble of its constitution. It declares that the enjoyment of highest attainable standard of health is one of the fundamental right, and every human being, without distinction of race, religion, political belief, economic or social condition. The phrase of highest attainable standard of health, which is commonly referred to the right to health, has since been endorsed by a wide array of international and regional human rights instruments. Soon after the WHO constitution was formulated, the right to health was affirmed by the Universal Declaration of Human Rights, which states that everyone has the right to standard of unemployment, sickness, disability, circumstances beyond his control. Sexual and reproductive health information and services, including family planning, underlying preconditions to health, for example, the right to safe water and adequate sanitation, and in general, the right to clean and safe environment. And lastly, the information about health. Broadly, in broad concept, the right to health contains two freedoms, uh, two essentials, that is, freedoms and entitlements. The freedoms include the right to have control over one's own health and body, as well as the right to be free from non-consensual medical treatment and experimentation. On the other hand, the entitlements include the right to access to an equitable system of health protection. The broad definition of health implied by the right to health encompasses both the curative and preventive aspects of health. It has been said that this dual focus corresponds with the distinctive perspective of clinical medicine and public health, both of which have influenced how the right to health has been defined and evolved. Whereas clinical medicine has traditionally focused on the health status of individuals, public health has focused on the need to promote and protect health of populations and to ensure conditions under which people can be healthy and remain so. Now, right to health in India. After 74 years of independence, the Indian state has failed to provide its citizens the basic requirements like food security, healthcare, housing, and education, which are the basics of reasonable human existence. Due to rampant poverty and lack of social equity, large sections of the populations have been denied adequate nutrition, clean drinking water and sanitation, basic education, good quality of housing, and a healthy environment, which are all prerequisites for health. A highly inequitable health system has denied quality health care to all those who cannot afford it. The first national health policy of 1983 made its motto health care for all by 2000, which has not happened, while the subsequent National Health Policy 2002 welcomes the participation of the private sector in all areas of health activities, thus, in the sense, endorsing inequity. The failure of national health policies to introduce social justice and equity has brought to the forefront the issue of need for the comprehensive legislative framework to empower the vast improvised masses of with rights for a healthy life, while universal access to healthcare will be the ultimate aim. The promulgation of the comprehensive legislative framework on right to healthcare would be prelude to the right to healthy healthcare as an enforceable fundamental right. Now, the historical perspective. We discuss in historic perspective. First of all, in 1943, a war committee led by Joseph William War was set up by the government of India to assess health conditions in India and suggest reform measures. It provided by the government primary health centers needed across the India, a nationwide health network that ensures no one is denied medical care for lack of ability to pay. In 1952, the government of independent India accepted committee's proposal. During the British period, the War Committee reflected the equivocal standing of Western medicine in India. The committee said that the healthcare should be available to all, regardless of their capacity to pay. It pointed out that death rate of 22.4 per thousand was twice that of England, and the infant mortality was significantly higher. The report recommended that any plan for the improvement of the health of the community should pay special attention to the development of measures for the protection of mothers and children. It attributed India's health problem to an unsanitary environment. The report underlined that at least 50% of the mortality existing in the country was preventable and should be prevented. To quote the War Committee, if we were possible to evaluate loss which the country annually suffers through the avoidable waste of valuable human materials and the lowering the human efficiency through malnutrition and preventable morbidity, we feel that the results would be so startling that the whole country would be aroused and would not rest until radical changes had been brought about. This report is published in Primary Healthcare India, Review of Politics, Plan and Committee Reports. Great emphasis was placed by the committee on the creation of primary health units. The committee claimed that far from being avoidable, Western medicines would meet the demands of new nation states. India was in need of state hospitals, doctors, and nurses. It recommended the health services based on the needs of the people. It emphasized the role of state in, in providing of basic health services. In 1952, there was a start to set up primary health centers to provide integrated promotive, preventive, curative, rehabilitative services to cover rural populations as an integrated component of intersectoral action. Asthana Declaration. In October 2018, the World Health Organization (WHO) organized a global conference on primary health care, from Alma Ata towards universal health coverage and the substantial development goals meeting at Astana, Kazakhstan. The Astana Declaration was signed, which aims to meet all people's health need across the life course through comprehensive preventive, promotive, curative, rehabilitative services and palliative care. India was a signatory to the Alma Ata Declaration in 1978 that assured health for all by the year 2000. Now, the constitutional provision in India. We'll discuss the constitutional provision in India. Article 21, which is a fundamental, one of the fundamental rights of the Indian, provided under Part 3 of the Indian Constitution, which is related to protection of life and personal liberty. Article 21 says, no person shall be deprived of life or personal liberty except according to procedure established by law. The right to life, enshrined as a fundamental right in the Constitution, makes a case for provision of emergency medical care and protection for all threats to life. The fundamental rights are guaranteed to all the citizens. These civil liberties take precedence over any other law of land. Next, the directive principle of state policies under Article 38, which provides that responsibility of the state to secure social order for the promotion of the welfare of the public health. Article 39E, the protection of health of the workers. Article 41, Article 41 says right to work, to education, and public assistance to certain cases. In certain cases, the state shall, within the limit of its economic capacity and development, make effective provision for securing the right to work, to education, and to public assistance in case of unemployment, old age, sickness, and disablement, and other cases of undeserved want. Next, Article 42 provides that just and human conditions of work and maternity relief, the state shall make provision for securing just and human conditions of work, and for securing just and human conditions of work, and for maternity relief. Article 47, which is also related, which is also related to the right to health, which provides that duty of state to raise the level of nutrition and the standard of living and to improve public health. The state shall regard the raising of the level of nutrition and the standard of living of its people and the improvement of public health as among the primary duties, and in particular, the state shall endeavor to bring about prohibition of the consumption, except for medicinal purposes, of intoxicating drinks and of drugs which are injurious to health. पहले अनम्यूट कर ले, जिससे किसी को अगर म्यूट अनम्यूट कर ले, म्यूट कर ले, म्यूट कर ले, किसी का आवाज रिफ्लेक्ट कर रहा है. हेलो हेलो.
Yes, sir, you're audible, sir.
Yeah, yeah, sir. Yeah. In next slide. Judicial leader. In case of Consumer Education and Research Center versus Union of India, 1995, the government has a positive duty to provide the basic conditions necessary to lead a life that is more than mere animal existence, including the right to health, right to clean environment, right to privacy. In case of Parmanand Katara versus Union of India, the Supreme Court said that whether the patient was innocent or a criminal, it is an obligation of those in charge of community health to preserve the life of the patient. It is an important judgment in case of Pancham Banga Khet Mazdoor Samiti versus State of West Bengal. The Supreme Court of India ruled that in a welfare state, the primary duty of the government is to secure the welfare of the people, providing adequate medical facilities for the people is in an essential part of the obligations undertaken by the government in a welfare state. In Article 21, Article 21 imposes an obligation on the state to safeguard the right to life of every person. The government hospitals run by the state, and the medical officers employed therein are duty bound to extend medical assistance for preserving human life. Failure on the part of the government hospital to provide timely medical treatment to a person is need of such treatment results in a violation of his right to life. Next, in case of Bandhua Mukti Morcha versus Union of India and others 1982, concerning bonded laborers, workers, the Supreme Court gave order interpreting Article 21 as mandating of right to medical facilities for the workers. Next, next. In the in case of in re of India 2000 on the health right of a mentally ill patient in AK Mittal versus state of UP, it is related to the rights of the patient in cataract surgery camps in Parmanand next in on the in common cause versus Union of India and others on the it is related to the case on the regulation of blood banks and availability of blood products. uh, on passive smoking in public place is it is related to it is Murli as Dwera versus Union of India, and in Hospital Acts versus Hospital Jet 1998, which is very important case relating to right to health on the right of HIV AIDS patients. Uh, Next, Vincent versus Union of India. It is related against hazardous drugs. These are the cases. इसमें आपने देखा यहाँ पर देखेंगे कि सुप्रीम कोर्ट ने जो जो फंडामेंटल राइट्स जो पार्ट 3 में दिए गए हैं, इसके अलावा सुप्रीम कोर्ट ने बहुत सारे ऐसे राइट्स ऐसे प्रोविजंस जो डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी में थे उसको भी एज ए फंडामेंटल राइट्स रिकॉग्नाइज किया है. यहाँ पर जैसे राइट टू हेल्थ, राइट टू क्लीन इन्वायरमेंट, ये सारे चीज जो हैं प्रोविजंस हैं, ये डायरेक्टिव प्रिंसिपल में होते हुए भी अब सुप्रीम कोर्ट ने इसको रिकॉग्नाइज कर दिया है एज ए fundamental rights. Next, now the current health of the health scenario. The National Health Policy 2002 clearly acknowledges that the public health system is grossly short of defined functioning is so far from satisfactory that morbidity and mortality due to easily curable diseases continue to be unexpectedly high and resource allocations generally insufficient. It would be detract from the quality of the exercise if, while framing a new policy, it is not acknowledged that the existing public health infrastructure is far from satisfactory for the outdoor medical facilities in existence. Funding is generally insufficient. The presence of medical and paramedical personnel is often much less than required by the prescribed norms. The availability of the consumables is frequently negligible. The equipment in many public hospitals is often obsolete and unusable, and the buildings are in a deeply dated state. In the indoor treatment facilities, again, the equipment is often obsolescent, and availability of essential drug is minimal. The capacity of the facilities is grossly inadequate, cumulative result of several interconnected changes. But even after these changes, the overall objective human rights, right, that is right to health. National Health Policy 2017. The third after the 1983 and 2002 did get something right to attempting to address the shortfalls when it came to infrastructure. It targeted government healthcare expenditure of 2.5% of the GDP, lower by the far than the global average of 5.4%, but a beginning at least. It promised to reform medical education and improvement hospital bed availability, clean up regulation of the sector, and improve the quality of and access to the public primary health care. Global global leaders adopted Delhi Declaration on Digital Health recently as a part of the high-level summit. The ministers and delegations adopted the Delhi Declaration on Digital Health for Sustainable Development. It was adopted at the concluding session of Fourth Global Digital Health Partnership Summit. The declaration calls for World Health Organization's leaders to in digital health and for it to establish a specific mechanism to centrally coordinate digital health to assist its member states. As we know, digital health or digital health care is a broad multidisciplinary concept that includes concept from an intersection between technology and healthcare. Digital health applies digital transformation to the healthcare field, incorporating software, hardware, and services. Now, India has one of the most privatized health system in the world, denying poor access to even basic health care. Mm, India, the Indian private healthcare systems are growing with their best performance and emerging as new distinction for the medical tourism. India is even moving towards into a new era of medical outsourcing, where subcontractors aim to provide services to the overburdened medical care systems in Western countries. Medical tourism in India is growing by 30% 30% a year, and Indian education system is searching out of the estimated 2,000 to 30,000 doctors and nurses each year. For Indian doctors, Western source could be greener, but for an increasing number of foreign patients, Indian hospitals are fast becoming their first choice. Most patients visiting India are from SAARC countries, but an increasing number of NRIs settled in USA and UK have also been availing the healthcare services in India. This trend shows that the metro cities of India have equipped with in India, but the socio-economic status of individual. The Indian health scenario is characterized by a declining public health system, resulting in urban rural disparities and putting the onus of health on out of pocket expenditure, which is overburdened the improvised masses of the country. The unrestrained growth of private public health system. The infrastructure and services need to be clearly defined and displayed at various levels. Basic medical services should be available to at primary and secondary level at all. Elimination of rural-urban disparities in provisions of health services should be at should be an immediate task. Basic public health services have to be made accessible to all citizens without discrimination. Second, establishment of rights and regulation and treatment procedures, especially in the private medical sector. Standard guidelines for investigation, therapy, and surgical decision making need to be adopted and followed, combined with legal restrictions on common medical malpractices, maintaining complete patient record at affordable cost, availability of all basic medications free of cost through the public health system. A national essential drug policy ensures the production and availability of an entire range of essential drugs at affordable prices. The union as well as the state governments should publish comprehensive list of essential drugs for their areas. A ceiling on the prices of these drugs must be decided and decided with production quotas and a strict ban on irrational combination and unnecessary additive to these drugs. Fourth, monitoring and accountability mechanism. There is a need to have people's monitoring of public health services at the national level complemented by following the principle of decentralization as outlined in the 73rd and 74th Amendment of Indian Constitution. The 73rd Amendment empowers Panchayati Raj institutions as bodies of self-government in the rural India, whereas 74th Amendment decentralizes the urban governance. The monitoring mechanism should be based on the principles of accountability, transparency, and responsiveness. Since good governance is essential to the effective implementation of all human rights, we need to propose an effective system of people's monitoring of public health services, which would be organized at the various levels in rural as well as urban areas. Public next rights relating to various sections of the populations which have of health finance and introduction of universal coverage of healthcare. Thank you.
Thank you very much, sir. Have you any question? Then you ask. Dear participants, if you have any question, then you ask.
Pranam says, I have a question. It's me, Dr. Nutan Kumari, an assistant professor from the Department of Political Science, TPS College, Bhagalpur University, Patna. So just now you have said that uh, there can be one remedy that health should be made as a fundamental right. But what do you think that it would be easy for our nation, which is a developing one, to make this health as a fundamental right? Because by making fundamental right, it will have to be enforceable, and enforcing as agency has to take care of. Then what would happen that all the states which are craving for power, they will have enormous duty to ensure this fundamental right. Yes, sir.
Like right to education. Right to education is was also not documented. But in the parliament added in Article 21A, right to education as a one of the fundamental rights. If parliament thinks so, then it may be possible to make it as a
When
fundamental
right to
right, right to
education
health.
is not being observed
Complete,
as
yeah,
fundamental
yeah,
right, there
complete
are so many
fundamental. It not,
lacks
it is a restricted right, and it is also given to the child of age of 6 to 14 years. But actually, right to health is state subject, is in the states list, state subject. लेकिन ये
education
बात
is
है कि
also
ये पॉसिबल नहीं है क्योंकि यहाँ पे इंडिया में कॉर्पोरेट फेडरलिज्म है है ना, बिना सेंट्रल गवर्नमेंट के असिस्टेंस के इट इज नॉट पॉसिबल टू achieve the right to health. So if it will become the fundamental rights, then duty is also upon the state government and union government to facilitate the health services in India.
संजीव जी नमस्कार।
नमस्कार नमस्कार सर, बोलिए कुछ। वीरेंद्र जी को बोलेंगे।
हाँ,
इनका क्वेश्चन का अभी जवाब दीजिए।
क्या है, व्हाट इज योर क्वेश्चन?
नूतन कुमारी हैं।
हाँ ना, इट्स ऑल राइट।
हाँ जी,
I have already interacted with her. So what is your question? What was your question?
Sir, my question is that if right to health is made fundamental right, sir, then don't you think that our nation, which is a developing one, it would be very, very difficult to ensure it? Because right to education, you are really thinking that how this fundamental rights is being
No.
taken in this.
Yes, I have understood your questions. The point is what? We are missing some basic points in it. The basic point says in Keshavanand Bharati case that these directive principles are complementary to fundamental rights. And at the time of commencement of Constitution, we have to understand this point that at that time fundamental rights are not inclusive in sense, but they were exhaustive in sense. So for the sake of industrialization or the social development, we were not in a position to enlarge the scope of that fundamental right. But today we can say that Article 21 is there, dignified life concept is there, and right to environment has so fundamental, and it is fundamental right in when dignified life is going to be infringed by state action. So right to health is a fundamental right. But the question is what? You have to prove that this right of health is going to infringe our dignified life. Then this right, so that is why I have said that these rights are complementary to each other. Okay. So today we can say that fundamental rights are inclusive in sense. It is not exhaustive in sense, but it is like when we say Vishakha versus state of Rajasthan, where it is written about the status of women at workplace. But so far treaties are concerned, Supreme Court has said that fundamental rights are also including those rights which are not in contradiction of fundamental rights. So in this way we can say that these rights are inclusive rights, and whenever it is going to infringe dignified life, it is a part of fundamental right. Okay.
He said, thanks, sir.
हाँ
और वीरेंद्र जी?
हाँ ठीक है। रुचि पूछ रही है, बताओ क्या पूछना चाह रही हैं?
क्या रुचि, क्या बोलो?
ऑन करो, पहले वो करो, अनम्यूट करो।
Sorry. Good afternoon, sir. I have a question, but it's not exactly with right to life or right to health. It's a very general question. Sir, recently on 14th December, UGC has published a notification saying that all female students, it's actually notification to all, addressed to all vice chancellors of universities in India, saying that all female students will get 240 days of maternity leave if they are pregnant in their course of their PhD or master degree, and it's even applicable to bachelor students. Sir, I don't know if this question is also reasonable, but will it not amount to inequality? Because generally it's 180 days for all other females, then why for students it's 240 days? I was just thinking when I read the notification, and I thought of asking Virendra sir, but now that both of you are available, sir, please.
First of all, you should ask Sanjeev sir.
Yes, yesterday when I read, I was just
ये तो हम
thinking.
देखे हैं अभी, just have seen this notification.
हाँ सर, 240 क्यों है सर उनका?
Then the question is what?
ये एक्सटेंड करिए, स्टेट गवर्नमेंट आप इसको एक्सटेंड करने जा रहे हैं फ्रॉम 180 to 45 डेज कुछ विथ 15 डेज पैटर्निटी लीव।
सर लेकिन अभी मैटरनिटी का जो नेशनल लेजिस्लेशन है, जो इन्फोर्समेंट वाली बात है, उसमें तो फिर सर 180 डेज है,
180 डेज है। हाँ 180 डेज।
ये नोटिफिकेशन सर वैलिड होगा क्योंकि सुप्रीम कोर्ट के सर, इसलिए बस मतलब will this notification be valid? It cannot be challenged.
नहीं संजीव जी, she is very right, but the basic what we are talking for or what we are here for is for the jurisprudential aspect of any notification, is it not? So when we consider jurisprudence, we have to see the Roscoe Pond's theory of balancing of interest. And also, Roscoe Pond has said that law is an institution having a full system, and that is it is law in functional sense. It is feedback sense. So government has got some data that this maternity leave should be extended, and the government is also having data to extend, and accordingly the government has extended that. So if it is not
अमेंडमेंट नहीं हुआ, जो एक्ट है उसमें अमेंडमेंट नहीं हुआ है
नहीं हुआ है
और
सर,
यूजीसी ने एक्सटेंड कर दिया है डेट
जजमेंट
को।
yes, it is not ठीक है, नहीं हुआ है, but this notification is in favor of female or not?
it is.
When you have accepted Vishakha versus state of Rajasthan, why not you are accepting this type of things?
No, sir, we are accepting, sir. We also want 240 days, sir. We just got.
This is not like that. If it is not challenged, it means that it is a part of that law. And it is in support of the welfare of the female. So that is why it is a feedback. It is a feedback concept. If government has registered no
for the welfare of women and children.
Actually, notification is what it is under this. You have decided the policy of the act, and under that policy, this notification has been considered. So if it is considered under the policy, it is okay. Then it is okay. It's all right. So law is what? If it is claimed or if it is challenged, and if it is accepted by the judiciary, then it is all right. Okay.
If you not accepted, then you challenge before the court of law.
Yes, sir. Thank you, sir. Thank you both of you. Thank you all of you.
For giving me chance.
Have you any question?
हेलो सर, मैं वंदना सर। हेलो,
बोलिए।
हाँ प्रणाम सर। सर मेरा कोई क्वेश्चन नहीं है, बट मैं ये कहना चाहती हूँ।
First you introduce herself.
हाँ सर, मैं डॉक्टर वंदना कुमारी मुंगेर यूनिवर्सिटी से हूँ सर, असिस्टेंट प्रोफेसर बीआरएम कॉलेज से। डिपार्टमेंट ऑफ फिलोसफी सर। तो मैं इसी ह्यूमन राइट्स में कोर्स करके सर बहुत सारे लॉ, बहुत सारे नियम की जानकारी मैं इससे अवगत हुई हूँ। मैं बहुत धन्यवाद देती हूँ सर। मुझे बहुत सारे नियम लॉ नहीं पता थे, लेकिन इस कोर्स में मुझे बहुत सारे नियम की जानकारी विभिन्न रिसोर्स पर्सन से हो रही है सर। थैंक यू सर, धन्यवाद सर।
Vandana ji, only I like to add to your knowledge that in India there is constitutionalism. संविधान बाद है, इसलिए whatever we do, it should be in accordance with the constitution. That is why in philosophy also, suppose you want some norms to be implemented in the society as per the philosophy, you have to convert those philosophical idea into norms. Then the public would be benefited by those ideas. So ultimately it is the law. It is not the physics. It is not the concept of anything that is going to be implemented in the society, but it is by making those ideas into norms. And that is why law is very important.
Yes,
one thing, madam, that idea we generated by getting the 1 cup of tea, green tea. Dr. Pandey sir.
Thank you sir.
Dr. Ajay Kumar Pandey, Principal, Art and Craft College. Unmute yourself, sir.
अजय पांडे, आर्ट्स कॉलेज पटना यूनिवर्सिटी।
जी।
नमस्कार सर।
नमस्कार जी सर।
जैसा कि वंदना ने अभी कहा कि वो बहुत सारी चीज़ों को जान पाए, मैं सच बताऊं कि जब से इन चीज़ों से हम लोगों का सरोकार है, वैसे भी सारे आर्टिस्ट संवेदनशील होते हैं, बहुत करीब नेचर के जो लॉ होते हैं उसके करीब होते हैं उनकी सोच। लेकिन हम लोग लगातार इस पर सोच रहे हैं, मेरे साथ साथी मेरे चंद्रभूषण जी भी हैं, हम लोग लगातार सोच रहे हैं कि अब हम नए तरीके के आर्ट किस तरह से प्रोड्यूस करें, क्योंकि हमारा अपना अलग तरीका होता है काम सोचने का। हम पढ़ जरूर रहे हैं, लेकिन हम उससे आगे जाके उसकी प्रोडक्ट मतलब मैं किस तरह से तैयार करूं, इन सारे सेंसेस को, जानकारियों को लेके हम कौन सा नया आर्ट वर्क बना सकते हैं, इस पे हम लोग चले गए हैं। ये हम लोग की कमजोरी भी होती है कि जहाँ कुछ मिलना शुरू होता है तुरंत हमारे सेंसेस उस पर काम करने लगते हैं, हम कोर्स भूल जाते हैं, बहुत सारी चीज़ें भूल जाते हैं, दोस्त मित्र भूल जाते हैं, फिर वो चीज़ें अंदर बार बार घूमते रहती हैं और जगह बनाती रहती हैं और फिर परिष्कृत होकर आप लोगों के सामने आती हैं, जिसको सभी लोग आर्ट वर्क कहते हैं। तो मुझे भी खुशी है आप लोगों से मिलके, आप सबके साथ कुछ सीख के। थैंक यू सर।
मुझे लगता है कि सर जो है आपका आर्ट बहुत ग्रो अप करेगा ये ह्यूमन आर्ट्स कोर्स करने के बाद।
वैसे भी मैं बहुत सारे इन्वायरमेंट के मैटर को बनाता रहा,
जी
क्योंकि 87 में जो पहला मैंने सीरीज शुरू किया था 1987 में अपने आर्ट वर्क की, वंस अपॉन ए टाइम देयर वाज अ रिवर, इस सीरीज में हमने करीब 32 काम किए थे कि एक रिवर किस तरह से डिस्ट्रॉय होते होते सिर्फ एक जगह बन जाती। बड़ा छोटा सेंस था उस समय हम लोगों का, लेकिन मुझे उस समय से ही माइंस पे मेरा मतलब अपना काम है, इस तरीके की जगहों पे काम है जिनमें मैं कभी मौका मिलेगा तो आप लोगों को जरूर।
अब मुझे लगता है सर कि आने वाले समय में जो आपका आर्ट होगा
जी,
उस आर्ट में
इसका रिफ्लेक्शन होगा, रिफ्लेक्शन
लॉ
होगा।
Human rights को reflect करेगा, जी।
लॉ इन्वायरमेंट का स्ट्रक्चर जरूर होगा उसमें।
नहीं, हाँ
Human
हाँ,
rights को reflect करेगा।
कितना
वो चालू हो गया है, उस प्रोसेस में हम लोग आ गए हैं।
थैंक यू
वो
सर।
अंदर चीजें ना वो धमनियों में दौड़ने लगी हैं चीजें, और नए दोस्तों को पाके, नए लोगों से मिलके, एक्सपर्ट लोगों से भी बहुत खुशी हो रही है। और ये एक स्टैग्नेंट जो लाइफ चल रही थी, थोड़ा उससे हम लोग हटे, इसकी भी खुशी है।
You know,
तो आप सबका बहुत बहुत धन्यवाद।
it was just
नूतन मैम को बिना मास्क का पहली दफा देख रहा हूँ मैं।
इसको देख रहे हैं।
Yes,
कितने
very
लोगों को
true.
बिना मास्क देख रहे हैं, विदाउट मास्क।